The Companies Act registration. Section 11, registration of articles. The articles, that's the articles of incorporation, shall be delivered to the registrar, who shall A. retain and register them if the articles comply with the provisions of this act, or B. where the articles are not in compliance, require that they be amended to ensure such compliance. All right. Section 12. No. Effect of registration. Subsection 1. On the registration of the articles of a company, the registrar shall certify under his hand that the company is incorporated, and in the case of a limited company, that the company is limited. Right, so you obtain a certificate of incorporation. Subsection 2. From the date of incorporation mentioned in the certificate of incorporation, the subscribers of the articles, together with such other persons as may from time to time become members of the company, shall be accompanied by the name contained in the articles. So from the date of incorporation mentioned, the subscribers of the articles, together with such other persons as may from time to time become members of the company, everybody together, shall be accompanied by the name contained in the articles, capable forthwith of exercising all the functions of an incorporated company, and having perpetual succession and a common seal. See that part, a common seal. So as soon as you have the articles, the certificate of incorporation, you obtain a seal. You go to a printery that deals with that, and you obtain a company seal or a stamp. That stamp will be required when you open the bank account for the company and to do certain other business. But with such liability on the part of the members to contribute to the assets of the company in the event of it being wound up, as is mentioned in this article. Section 13, Certificate of Incorporation, to be conclusive evidence. Subsection 1. But there is only one subsection to section 13, but anyway, we read it. A certificate of incorporation given by the registrar in respect of any company shall be conclusive evidence that all the requirements of this act in respect of the registration and of matters precedent and incidental thereto have been complied with, and that the company is authorized to be registered and has been duly registered under this act. So once you present the certificate of incorporation, you don't need to present any other evidence that the company exists and has been registered. Section 14, restriction of unlimited registration of unlimited company as limited. Subsection 1. Subject to the provisions of this section, a company registered as unlimited may register under this act as limited, or a company already registered as A limited company may re-register under this act, but the registration of an unlimited company as a limited company shall not affect the rights or liabilities of the company in respect of any debt or obligation incurred, or any contract entered into by, to, with, or on behalf of the company before the registration, and those rights or liabilities may be enforced as provided by this act in the same manner in all respects as if no such change of registration had taken place. So re-registering as a limited company, you still owe the money, the company still owes the money that it owed before. It's still obligated to carry out the contracts that it signed before, and so on. Those are not affected by the re-registration. That seems to be what that is saying. Subsection 2 of section 14. On registration in pursuance of this section, the registrar shall close the former registration of the company and may dispense with the delivery to him of copies of any documents with copies of which he was furnished on the occasion of the original registration of the company, but save as aforesaid, the registration shall take place in the same manner and shall have effect as if it were the first registration of the company under this act. So re-registering is not really a re-registering on our new registration. It's like the only registration. It's like the first registration of the company. Right? The registration shall take place in the same manner and shall have effect as if it were the first registration. So those re-registering have to provide all documents as if they were registering for the first time. The previous registration, they can rely on that and say, well, I don't have to submit this document because it was there already. No, you have to submit all documents as if you were registering for the first time. Subsection 3. Where a company limited by shares re-registers as a company limited by guarantee, so you go from a profit-making company to a non-profit, the amount of the guarantee shall not be less than the amount remaining unpaid on the shares. Alright, so whatever the company owes the people, it still owes them. The amount of the guarantee shall not be less than the amount remaining unpaid on the shares. Right, provision with respect to names of companies. We will look at that later.